Good afternoon. Good afternoon and welcome to our real estate webinar titled Landlords and Tenants, Practical Tips for the Pandemic and Beyond. For those who don't know you, I'm Richard New. I'm a partner in the real estate dispute practice here, and I'm joined by my colleagues Christopher Bartley, who's going to talk about landlord and tenant law and how coronavirus has affected the remedies available to landlords, and give some practical tips on what landlords and tenants are doing at the moment. I'm also joined by my colleague Costa Keliris, who is going to talk about the recent Supreme Court decision in Duval and the trouble a landlord got in when he allowed a tenant to make alterations to a building in breach of an absolute covenant. I'm going to start off the session today and talk about something actually that's slightly, it is landlord and tenancy, but basically affects all sorts of corporate occupiers, and that's about business rates. Now you can imagine at the moment and for the last few months, there have been one heck of a lot of empty properties around, or partially occupied properties. And corporate ratepayers are looking to think, well, what can we do to try and mitigate our business rates? We might be in discussions with our landlords about getting rent reductions, but business rates usually are about half of open market rent. So what can we do about those? So for the next 10-15 minutes or so, I'm just going to run through what we've been advising some of our clients to look at and some of the reliefs that are available to corporate occupiers across the board. Now we'll start off with the additional government reliefs that were announced by the government shortly after all the restrictions came in place for COVID-19. And obviously there was a forced closure list that was issued by the government. And shortly after this, the government decided to expand what they call the retail discount, whereby all corporate occupiers in the retail, hospitality and leisure sectors will get 100% discount on their business rates for the financial year 2020 to 2021. Now that's all shops, pubs, bars, restaurants, nightclubs and the like. And if you need any further information about that, then I've put the web link at the bottom of that slide, which will circulate later, in order to give you some more advice about that. Now the interesting thing about this is that if obviously you actually have got an empty property at the moment, the government will classify your premises as occupied for the purpose of obtaining this discount. And it is something that has gone to local authorities in terms of guidelines in order to issue. So you should be automatically getting 100% discount if you are in the retail, hospitality and leisure sectors. Now the government said that this is going to be a £10 billion relief fund for those in those sectors. So you would have thought they're both getting the big thumbs up, well done government. But unfortunately, it's not entirely the case because there has been some controversy about bringing this in. Firstly, obviously, I mentioned about the forced closure list. Well, this actually goes slightly beyond that. And actually, there are some parties and some types of uses who are getting 100% discount at the moment, but who've actually decided or can stay open throughout the course of the pandemic. So you probably have seen in the newspapers, the supermarkets in particular have borne the brunt of this. They've managed to stay open, making a decent profit at the moment, and also they've managed to get a huge windfall, managed to get 100% discount on their business rates for the period of the pandemic. You might have seen yesterday as well that a broadsheet took aim at a certain Mr. Trump, who owns a couple of golf courses up in Scotland, who are also benefiting from this exemption. I think he was quite heavily attacked about that and the corporation tax that has or hasn't been paid on those properties the last few years. The second point as well is that Chris is going to talk about landlord and tenant remedies later, and he's going to talk about things like winding up and how the government is trying to pull back on certain landlord remedies which are linked to tenants who are in financial distress, those who can't pay their bills because of coronavirus. Well, this retail discount doesn't take account of balance sheets, how much money these entities have got in the bank. and therefore some people have said actually they might have gone too far in certain instances in terms of the relief granted. But I think thirdly, and most importantly, there's a question mark about, well, what about the other occupiers? It's not just the retail, hospitality and leisure sectors that have been affected by the coronavirus. It's been across the board. We know it in the Mills Reeve, offices, industrial and the like. Every occupier has probably been affected to a certain extent by coronavirus. What can we do in terms of our business rates for liability? Well, the answer to that is you've got to look within the confines of what was already available to you in respect of business rates reliefs. And I'll outline some of these now. Now, the first thing you might look at actually is just your simple empty rate relief. So if you've got an unoccupied property, you can get 3 months or 6 months, if it's an industrial premises, rate relief once you vacate the property. So at the moment you might think, well, I've got an empty property, I could get my 3 or 6 months rate relief. Unfortunately, obviously, it's not quite as simple as that, and this can be very fact specific. For the purposes of business rates, usually occupation of part of a property equates to occupation of whole. So if you think about it at the moment, if, for instance, for an office user, if you're actually using the premises sporadically, if you are, got facilities there who are doing photocopying, sending out deeds, the like, you've got iced tea servers stored within there which are actually servicing your remote workers, or you've got, say, goods in the premises that you're actually going to sell after the event, then potentially that will be occupation of part, at least part, and probably won't classify you for this empty property rate relief. But on the other hand, there's a few other circumstances I've outlined at the bottom of that slide. At the moment, you might think, well, actually, I've got a skeleton staff in at the moment. Just to say a security guard, occasional cleaning and the like. Does that mean I can't get an empty property relief? Well, the answer is actually, if you've got a skeleton staff, then in accordance with rating law, you're probably okay in that actually you can't occupy the premises for the purposes of the use you want it to do and for business rates purposes. So you might be able to get away with it on that instance. There's also something as well, there's an exemption for plant, machinery and equipment that's left on premises as well. So you might think, well, actually, I've still got files in situ, I've got my computers, office furniture, how are they dealt with? Well, it could well be that actually they do fall within equipment as per the statute, which actually would be disregarded in respect of whether a property is empty or not. Obviously, plant and machinery, there are certain regulations relating to that, particularly with regard to business rates. There's probably over the equipment exemption where it's most going to be probably the biggest battleground as to whether equipment should be narrowly defined or whether actually it could be quite widely defined to include those kind of things that I've already touched upon, such as office furniture, computers, active files and the like. If you do have a genuinely empty property in terms of the legislation, then you might also think about employing a mitigation scheme. Now, the way that legislation works at the moment is that if you are in occupation of a premises for 6 weeks, you can then avail yourselves of the empty rate relief of 3 or 6 months once you vacate. You could then go back into occupation for 6 weeks, and then you could vacate again and get the exemption again. And you can repeat that ad infinitum. Now, obviously, there's a lot of sniffiness about mitigation schemes. People always think, well, actually, hang on a second, business rates is a tax. It's not some sort of avoidance scheme. And yes, quite a lot of these mitigation schemes you see, which make use of this 6 weeks occupation triggering the empty rate relief, are artificial. At the moment, quite a lot of them have been held to be lawful through the courts. And there's quite a lot of case law that's been clogging up the high courts, magistrates courts and the like over the recent years. So some of the schemes you may look at are storage. You might want to use your premises for storage for 6 weeks, either through your own use or using a third party. Certain ratepayers have availed themselves of putting charity shops into their stores in order to actually get the occupation for vacation. Some obviously works in a similar way to storage. You can actually put Bluetooth transmitters into premises, and that potentially can qualify as 6 weeks occupation just through having a Bluetooth transmitter, albeit there are some question marks as to whether that constitutes occupation or not. You've probably also seen there's been quite a lot of press about it recently because there have been 2 big cases. There's also been the ability to actually employ a mitigation scheme using property guardians, whereby you go in and actually you ask residential tenants to take certain rooms within your corporate building, and they actually live in there while the property is vacant, and then you can basically get yourself potentially on the council tax scheme, which is much lower than through business rates. And finally as well, another case that's been recently heard by the High Court involved in an insolvency scheme, whereby ratepayers were granting a lease to a tenant who then put themselves into insolvency and then claim the benefit of the suspension of business rates that you get through the insolvency legislation. So there's plenty of these kind of schemes out there, which potentially can mean that you can start re-triggering the empty rate relief that you can get for your properties. The other reliefs that are potentially available in business rates from the local authorities are on this slide. First of all, there's Section 44A relief. Now, this is a discretionary relief which the local authority can grant on partially occupied properties. Now, we usually see these where there is a clearly defined or clearly isolated part which you can say is not occupied of your premises. And traditionally these were seen when, say, there's been a phased vacation or occupation of, say, an office, floor by floor and the like, where there are clearly defined parts that are being used and some that aren't. I said this relief, is discretionary for the local authority. It's got to be for a short-term basis, and if the local authority doesn't grant it, then really your only remedy is to seek judicial review, which sometimes isn't the most the quickest or cheapest of remedies to go for. The other one I've mentioned on the slide as well is hardship relief, and again another discretionary relief that a local authority can bring in where there are unforeseeable and exceptional circumstances for a ratepayer. And basically it's meant to cover like a temporary crisis. And at the moment, of course, you might argue that a lot of businesses are in crises because of coronavirus, and I'm struggling to see whether a lot of local authorities are going to look to give hardship relief out at the moment in the current circumstances. Now I'm going to come on now to 2 areas which are likely to be hotly contested over the next months, years. And the first one involves a relief that you can get if you're a ratepayer, and it's a full relief, if the occupation of your premises has been prohibited by law or by the action of the Crown or by a public body. Now, a lot of ratepayers may look at this and say, well, hang on a second, the government has issued coronavirus restriction regulations, Coronavirus Act, which has forced the closure of certain businesses, or there have been guidelines which mean that actually we can't go into our business, or that people have been encouraged to work from home, we can't use them. Surely we can make use of this prohibition exemption and get relief. Unfortunately, it's probably not quite so easy as that. Generally, and in the past, this relief has been interpreted very narrowly in terms of actually what prohibition by law means. And there's been a very strict interpretation that there's got to be a direct relation between the law prohibiting your ability to go in and actually use your premises. So if you think about it at the moment, you might say, well, actually, there are guidelines on social distancing, no assembly, working from home. There are restrictions on movement and transport. Do those qualify though as, prohibition by law, in terms of actually the guidelines issued by the government? And you've also got to take other things into consideration as well, in terms of actually, are you using the premises to any degree at the moment? And also actually, this is actually about the occupation of the building, not actually occupation for the use that you want to put it. Could actually the occupation be for another use, which actually isn't prohibited by any sort of law or guideline or restriction? So there's lots of question marks actually at the moment as to whether ratepayers can avail themselves of this relief. Now, the last point I want to touch on in terms of the business rates side of this talk is about material change of circumstances. Now, unlike the others I've mentioned on this talk so far, this isn't a relief that you seek from the local authority. It's actually an application to the valuation office to get the rate or value of your premises changed for a certain period of time, which you do through the check challenge appeal. And I understand from my rating surveyor contacts, there have been a multitude of these put in at the moment because of the COVID-19 crisis. Now, what is a material change in circumstance? Well, it's a matter that's not present when the rating list has been compiled that has affected the rateable value of your premises. Now, in terms of this matter, it has to be a physical change. As I put on the slide there, a material change to the physical state of your property or in the locality in which your property is situated. Now, there have been a couple of well-known cases recently on material change of circumstance in terms of Alton Towers and Wigan Football Club. And what's clear from those is that this material change, the physical state, it can't simply be an economic or market force. It's got to be a physical change. So the first question you've got to ask yourself if you want to go down this route and put in a check in terms of actually a material change is whether actually there has been a physical factor that has changed the physical state of your property or the locality, and which has caused a reduction in value of your property. So obviously each property you might think about is going to be affected by different factors, because each property will have different characteristics. So you might say, actually, well, working from home's affected me. There has been a material change because we haven't got as many people in our property as we usually did. There have been restrictions on transport that have affected my property. Social distancing, even when we're in the office or the premises itself, the internal configuration of our buildings had to change to take into effect social distancing rules. You might say there's been a reduction in footfall outside your premises. The closure of nearby businesses has affected your trade, or maybe it means there's been an overabundance of competing space, which again might have impact upon your value. So there are various factors, various material factors you might have to think about, which potentially could be changes to the physical state of your premises caused by COVID-19. But again, even once you've identified those physical changes, you've then got to also ask two other pertinent questions. First of all, how does it affect value? And I'm sure there are plenty of surveyors on this webinar who might be in a far better position to tell you as to whether the physical change has affected the value of your property or not. And also, for how long has this, does the reduction in value last? These material change in circumstances, your typical one in the past has been, say, roadworks outside your building. Temporary has a temporary effect. The value goes down for a while, then perks back up again. How long is this reduction in value going to last? What is the true effect? Again, it's something that if you haven't already, you should be discussing with your rating surveyors ASAP. Particularly because I said, as I put on the last point there, that actually you better get your check challenge appeal in quite quickly, because actually it's the receipt of the check by the valuation office which determines what the material day is. And so if you don't get your check in quickly, obviously as days go by, these restrictions are being lifted. And so the quicker you put your check in, then the better for these purposes. Now, I should have mentioned, apologies before we started, and before I hand over to Chris, that we are doing something slightly different in terms of Q&A. You know, if you do have any questions while these talks are going on, please feel free to put them into the Q&A box that you'll see on your screen. Some people have already put in questions beforehand, which have informed the thrust of some of these talks. But for those actually who are putting questions in, because of the number of people on this talk and of course the diversity of the audience, what we'll most likely do is we'll try and pick out some common themes which we might touch upon at the end of these talks if we've got time. But however, please don't let that stop you putting in questions, because for those of you who do put questions in, what we'll do is we'll save those, anonymise those, and the answers to your questions we'll post on our coronavirus hub on our website following the end of this talk, and once we've had an ability to address them obviously as well. So please feel free to put Q&As in into the box as you can see them on your screen as we go along. But for the time being now, I will hand over to Chris, who will now go through some of the landlord and tenant factors at play during the COVID-19 pandemic.
Thanks, Richard. And thank you everyone for joining us today. I'll just wait until I can move the slides. Yes, thank you everyone. So this webinar, of course, is set against the backdrop of extremely challenging times for commercial landlords and tenants. Indeed, a survey by Remit Consulting showed that just 48% of rent due was paid on the March quarter day, increasing to 57% 7 days later, and the equivalent figures for the preceding year were 79% and 90%. We've also seen rapid developments in the law, and during the next 20 minutes you're going to hear about some of those developments in the context of commercial property, particularly in relation to landlords' restrictions during the pandemic. So to begin, I'm going to look at the options that were available to landlords prior to the lockdown, and then we'll then compare those with the options available presently. So in terms of the main options available in the pre-pandemic landscape, we had court proceedings by way of a money claim for arrears or to enforce covenants. We also had a rent deposit, if there is one, and subject to its terms. There could also be a claim against a guarantor, again if there is one, or indeed a previous tenant or its guarantor. We also had commercial rent arrears recovery, whereby the landlord may instruct enforcement agents to take control of the tenant's goods where rent is unpaid, and that is a statutory procedure following the service of notices and set timeframes. Of course, there was also forfeiture, whereby the landlord forfeits the lease following the tenant's breach of covenant, bringing it to an end, and the lease is forfeit by the landlord peacefully re-entering the premises, or if necessary, commencing possession proceedings. Also on the slide there, we have statutory demands and winding up proceedings. Indeed, during the pre-pandemic landscape, the service of a statutory demand of itself is often a useful tactic employed by landlords to place pressure on tenants to pay arrears. So moving now to the restrictions that are in place currently. I've highlighted in red there the remedies that currently have direct restrictions placed upon them, and we're going to go into those in a bit more detail now. It's worth noting, however, that even those remedies that don't have direct restrictions placed upon them, they inevitably are indirectly affected by the current crisis, and again we're going to touch upon those. So we'll begin with commercial rent arrears recovery, also known as CRAR. Now, on the 25th of April, new regulations were brought into force the effect of which is to extend the level of arrears required before a landlord can invoke the CRAR process. And the extension is now that has been from 7 days worth of rent in arrears to 90 days worth of rent in arrears. The change applies to any enforcement given between the 25th of April to the 30th of June, although note that this relevant period is capable of being extended. So its aim is to give tenants breathing space and to enable it to essentially cope with the current crisis without the threat of CRAR being exercised against it. But of course, 90 days from the March quarter date is due to expire. It will expire on the 23rd of June. And so CRAR could once again become available for many landlords in connection with non-payment of March quarter's rents. That said, it remains to be seen whether either that period or the restrictions in general will be extended or amended, and we're going to touch upon that in a bit more detail shortly. So of course, forfeiture. The looming possibility of forfeiture is often the jewel in the landlord's crown when it comes to encouraging tenants to give prompt payment of rent and otherwise adhere to the covenants under the lease. However, pursuant to Section 82, subsection 1 of the Coronavirus Act 2020, it states rather bluntly that a right of re-entry or forfeiture under a relevant business tenancy for non-payment of rent may not be enforced by action or otherwise during the relevant period. And so rent for these purposes includes any financial payment under the relevant lease. So that can include not only the headline rent, but also, for example, service charges or indeed insurance rent. A relevant business tenancy is a tenancy where the demised premises are occupied by the tenant or any lawful occupier. So that can include a subtenant or a licensee. The occupation needs to be for business purposes, whether that's the tenant or the lawful occupier, but that is the case even if the lease is contracted out of the security of tenure provisions in the 1954 Act. And so for the purpose of the moratorium on forfeiture, the relevant period is the 26th of March to the 30th of June. However, it is likely to be extended, and I'll touch upon that in a bit more detail shortly. Some of the key points to note in relation to this moratorium: the rent remains due and payable by tenants, and therefore, in many ways, this moratorium and indeed a number of the other restrictions are intended and designed to offer breathing spaces for tenants. They're not intended to give wholesale relief, and the danger is therefore that once the restrictions are lifted, landlords will seek to enforce the remedies under the lease and which are available by law, and you could see forfeiture taking place once a relevant period it expires, unless it's replaced by something different. Now, the rent will remain due and payable, and forfeiture can be enacted once a relevant period expires, unless the ability to forfeit has been waived by the landlord, but the Act makes clear that that act of waiver needs to be expressed and it needs to be in writing. So simple forbearance won't of itself constitute waiving the right to forfeit. Equally, any arrears which accrued prior to the coming into force of the Act is essentially caught, because the moratorium is in relation to the landlord taking action in relation to forfeiture, not in relation to the underlying obligation to pay. And so moving on now to another key restriction. Practice Direction 51Z has now been inserted into the Civil Procedure Rules. So the Civil Procedure Rules, essentially as a brief recap, sets out the procedural framework within which parties and indeed the courts to litigation are expected to follow and adhere to. And the result of this new practice direction is to state that all possession proceedings brought under CPR Part 55, which is the relevant part through which a claimant landowner will seek possession of property, is essentially stayed for 90 days from when the direction came into force. and the direction came into force on the 27th of March. The potential breadth of this stay caused a fair amount of commotion when it was first introduced, so much so that it was amended shortly afterwards to make clear that it doesn't apply to claims to trespassers, and it doesn't apply to certain case management directions where the directions are agreed, or indeed interim possession orders, albeit that IPOs aren't something that's encountered very regularly in practice. The direction from the outset did not apply and does not apply to claims for injunctions, which are not brought under Part 55, they're brought separately, even though injunctions in certain circumstances, when relevant conditions are fulfilled, can be used to require an individual or a corporate body to move from a parcel of land. Indeed, the use of an injunction during this stay in possession proceedings was highlighted in the case of University College London Hospitals Trust, an MB, involving an ex-patient who refused to leave a hospital bed. In that scenario, the court awarded an injunction, notwithstanding the stay in proceedings, in view of the fact that an injunction can be used to require somebody to move from a parcel of land, and it is a remedy that's available independent of the ability of a claimant to pursue possession proceedings under Part 55. That said, it's worth pointing out that injunctions, they're a discretionary remedy. A judge does not have to award an injunction, even if all of the other relevant conditions are fulfilled. And indeed, there's a whole body of case law which sets out when an injunction is appropriate and when it is not appropriate in the context of land. And indeed, the ordinary remedy for a claimant to follow would be for a possession order under Part 55. And of course, that's currently stayed. So I'd suggest that the use of an injunction is certainly an exception that we will only see in very unique circumstances during the general stay of proceedings. So of course, again, which also demonstrates how quickly time has passed since the restrictions were first brought into place. But 90 days from the 27th of March is due to expire very, very shortly. And indeed, there were question marks up until fairly recently as to whether it's going to be extended. Those question marks have now been answered. A new statutory instrument was laid before Parliament only yesterday, and it has obtained approval, and it states that as from the 25th of June 2020, there is a new part to Part 55, new Part 5529, which will extend the stay of possession proceedings until the 23rd of August. So essentially, for practical purposes, the stay of possession proceedings has now been extended to the 23rd of August. So we've seen just now that the stay of possession proceedings has now been extended, and that begs the question as to whether the extensions to the moratorium on forfeiture or the restrictions on CRAR will also be extended. I strongly suspect that they will, and I'll talk about that in a moment. I think it's worth noting, however, how, quite frankly, incredible it is that there is still a degree of doubt, at least, as to whether extensions will be brought into place in relation to forfeiture and CRAR. They are due to expire in the next couple of weeks. And indeed, when you think about June quarter's payment and when that falls due, many tenants will be starting their payment run now to ensure prompt payment. And they're doing so within the backdrop of this uncertainty as to whether these current restrictions on remedies will be extended or not. That said, it's clear from recent press releases by the government that the intention is to, I think if we can think of the country as a whole being on life support in a way, is to try and ease the country off that. And I think we're going to see something similar in relation to these restrictions. So I suspect that we're going to see at least one further set of extensions in relation to the moratorium on forfeiture and indeed the restrictions on CRAR by impression is that that's probably going to be until the end of August, similar to the stay of possession proceedings. But I think all we can do at this moment in time is watch this space. I suspect there will be further policy announcements by the government in the next day or so, quite frankly, in view of June quarter's impending arrival. And indeed, what I propose to do following this talk, as soon as we do have further update in relation to that, I'll send everybody a short note updating everyone on the position. What has been announced by the government is a new code of practice that's currently, the idea is that that's going to be introduced in time for the June quarter day. Now, the UK government has been working with a number of key stakeholders that you would see along the chain of a landlord and tenant relationship. So not only tenants, not only landlords, but other stakeholders, including lenders, for example. And they're working and trying to finalise a code of practice. It's intended to govern how parties will address rental payments over the coming months and during the pandemic. It's intended really to encourage collaboration between both landlords and tenants, and really to try and make sure that no part along the chain bears most of the burden. I think it's fair to say that the moratorium and forfeiture and the other restrictions that have been put in place have meant that landlords in particular have felt a lot of pressure because they have been unable to exercise any remedies in order to encourage payment. And indeed, I think it's fair to say that some tenants have taken advantage of the restrictions to secure rental concessions of varying nature. And that notwithstanding, landlords will still have their own obligations to fulfill, whether that's in the form of their own lending obligations or otherwise. And so part of the code of practice is intended to redress the balance. Initially, the code of practice, it's not intended to be mandatory. And because of that, I really do think that the extensions on the moratorium for forfeiture and indeed the restrictions on CRAR are probably going to be extended because otherwise the code of practice, if voluntary, may not be followed. I have had a look at one of the early drafts of the code of practice, and to be honest, it's a bit woolly. Certainly its first draft was. It talks about parties working together without a great deal of substance behind that. One point it did mention, however, is that where tenants are seeking an understanding from landlords, whether that's through rent holidays or concessions, the tenants will be expected to disclose sufficient financial information to enable the landlord to make an informed decision, which is an interesting step. And indeed, in relation to lenders, landlords lenders, they equally will be expected to adopt a reasonable approach upon the landlord approaching it with details about how certain relief might be required. So again, watch this space. It's likely to be brought into play before the up and coming quarter day. So the final key direct restriction that I wanted to speak to you about relates to statutory demands and winding up petitions. So as early as the 23rd of April, which seems in many ways a lifetime ago now, the Business Secretary announced a moratorium affecting stat demands and winding up petitions. There was then weeks of relative silence and a degree of mystery, in all fairness, about this piece of legislation that was coming into force. But now the Corporate Insolvency and Governance Bill, and all 240 pages of it, is now working its way through Parliament. It's likely to come into force on or around the 25th of June, is the current thinking. That said, however, and this is a key point, it's likely to be retrospective in its nature. Indeed, and furthermore, in the very catchy sounding case of a company injunction to restrain presentation of petition, a High Court judge recently granted an application to restrain a winding up petition in view of the Corporate Insolvency and Governance Bill's impending enactment. The judge felt that by the time that the winding up petition was heard at a final hearing, the bill is likely to be in force in a fairly unamended form, and its effect will be retrospective, and therefore there's no point allowing the winding up petition to continue. I mean, that's quite a I'd probably suggest a bold decision for the judge to take, essentially predicting legislation that's yet to be enacted. But certainly what we're hearing from our contacts is that a number of other judges are making similar decisions, albeit in private court hearings. So it's likely to be enacted towards the end of June, and one of the key provisions will be that no winding up petitions are to be presented on or after the 27th of April if they rely on statutory demands during the relevant period. So yet another relevant period in the context of this legislation, and in relation to this bill, the relevant period runs between the 1st of March and the 30th of June, or if later, the 1 month after the bill comes into force. And so based on current estimates, the relevant period will run from the 1st of March to the end of June. So ultimately, that means that any statutory demand served during that period will be of no legal effect, at least, and cannot be relied upon. Furthermore, no winding up petitions are to be presented during the relevant period unless the creditor, and that's a key point, has reasonable grounds for believing that the coronavirus has not had a financial impact on the company, or that the debtor company would be unable to pay its debts notwithstanding the coronavirus. So, I mean, I would suggest that's going to be very difficult for creditor landlords to satisfy themselves at the point in time when they decide whether or not to present a winding up petition. It's going to be very difficult for a creditor landlord to know the ins and outs of a debtor company at that particular point in time. And I suspect very strongly that tenants, debtor companies in general, are going to be quite unwilling to disclose all of their financial information at the request of the creditor. Indeed, it's also worth noting that the court must also take into account the financial effect that the pandemic has had on the debtor company. And again, the court can only make a winding up order if it's satisfied that the coronavirus hasn't had a financial effect on the debtor. Finally, because of the retrospective nature of the legislation, any winding up orders that have been made since the 27th of April, if they would not have been made had the legislation been in force, they are automatically deemed void, which is quite a strong piece of legislation in the sense that it's automatically deeming void winding up orders that would be made perhaps quite correctly since the 27th of April, but before the coming into force of the legislation. And the court has the power to restore the debtor company to the position that it would have been immediately prior to the presentation of the winding up petition. So again, even though this legislation is not in force yet, people are already talking about whether or not the relevant period here will be extended. And again, the current impression and view is that it probably will, again, to the end of August, if needs be. But at this moment in time, it looks like it's going to be running from the 1st of March till the middle to the end of July. So what does that leave us with? What's left? We still have debt proceedings, of course. We still have court proceedings. And in that regard, the courts are still functioning, albeit it's a bit of a mixed picture. I checked on Tuesday, and at that point in time, there were 168 open courts. So they're buildings that are open to the public for essential face-to-face hearings. There were 109 staffed courts. So staff and judges were working at those courts, albeit that they were not open to the public. And there were 64 courts that were closed temporarily. And indeed, the court has embraced technology where it can. It's been holding virtual hearings where appropriate. And so court proceedings are still an option, albeit it must be noted that it could take some time, and inevitably the court is under a huge amount of pressure and burden, administrative and otherwise, in terms of a backlog of cases. So you still have rent deposits, of course, if there is one, and depending on its terms. And related to that, in certain circumstances, an eye must be kept on whether the tenant has entered into a formal insolvency process. We also have the option of pursuing a guarantor. Again, if there is one, and subject to that guarantor's financial standing. And then it's important not to overlook the ability of a landlord to take proceedings against or pursue a former tenant or that tenant's guarantor. In the case of more modern leases, it's worth noting that the landlord would need to serve a Section 17 notice within 6 months of the fixed charge or debt becoming due, and the recipient of a Section 17 notice, if they pay the amount owing in full, is entitled to call upon the landlord to grant it an overriding lease, albeit I query how many former tenants or guarantors would wish to become their former landlord's immediate tenant in the current climate. Nonetheless, it is certainly something to keep an eye on. So time is against us, unfortunately, but one final point, of course, relates to insurance. Many landlords and tenants look towards business interruption insurance when this crisis first arose. The immediate response of insurers was to say that business interruption insurance was not applicable in this scenario, albeit due to the clear importance of that particular issue, the Financial Conduct Authority is pursuing declaratory proceedings on the point. The latest we heard is that I think the FCA is taking forward around 8 examples of policy wording and seeking declarations from the court as to whether or not business interruption cover is engaged in relation to those particular examples of policy wording. So again, watch this space. The FCA are providing regular updates on their website, and a link to their original press release is found in that slide there. So thank you ever so much. I'm now going to pass you over to Costa, who is going to provide insight and update in relation to the recent Supreme Court decision in Duval. Thank you.
Afternoon, everyone. Thank you for that, Chris. That was really interesting. Duval and 1113 Randolph Crescent. This was a judgment which was handed down only about a month ago by the Supreme Court, which has quite wide and significant implications for both landlords and tenants, particularly in respect of leases of blocks of residential flats. As some background, Randolph Crescent is in Maida Vale, and if anybody knows Maida Vale, it's a very nice area. It's a block of 9 flats, and it has at the back, and I don't know if anybody knows the area, has a very large communal garden, very attractive garden. It's only a short walk from Warwick Avenue Tube Station. And properties in the Maida Vale area are quite expensive. And in fact, a 5-bedroom maisonette in this block was sold back in 2015 for £4.5 million. So quite valuable flats. And this is probably why this case was heard and why we haven't seen this case argued previously. The building was originally 2 mid-terrace houses, and it formed part of the Church Commissioners' Maida Vale estate. Back in the 1980s, the Church Commissioners converted it to flats and granted 125-year leases. And each of the leases were principally all in the same terms, and I'll come on to that. The freeholding of the building was acquired by the landlord company back in 1986, and as required by all the leases, each flat owner is a shareholder of the landlord company. So in effect, Mrs. Duval, in a way, sued herself. The leases of the flats do not include, and this is important, any of the load-bearing walls. I won't go through the list of what isn't included, but basically that's it. So the first point we need to consider, and if the first slide could be put up, is some of the tenants' covenants, which is clause 2.6, which provides, and you can see there, not without the previous written consent of the landlord to erect any structure, blah, 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 nor make or suffer to be made any alteration or improvement or addition to the demised premises. That's quite straightforward. Normally, most leases, and this is what we call a qualified covenant. And being a qualified covenant, then consent is not to be unreasonably withheld. So if we go on to the next slide, clause 2.7, this is really the relevant clause, and it is not to commit, and this is on the tenant, not to commit or permit any waste, spoil, or destruction in or upon the demised premises, nor cut, maim, or injure, or suffer to be cut, maimed, or injured the roof and walls, within or enclosing the demised premises. This is a absolute covenant, and just for those who wonder what waste is, I've just put a little explanation there. It's the willful spoil or destruction of property, which is an old word, but you don't see it very often in leases today. So then the next clause, next page we need to look at, next slide, is clause 319, and this is the one which Mrs. Duval was relying on in this case, is that every lease in this block building had to be granted, if it was bought for a premium, regulations that were to be observed by the tenant, and also to contain covenants of a similar nature as clause 2 and 3, which we've just seen. And at the request of the tenants, and subject to payment by the tenant, and also provision of some security for the costs on a complete indemnity basis, to enforce any covenants if requested to do so by the landlord. This is what happened here. So these clauses are quite common in many blocks of flats across the country, and particularly important in London. So back in 2015, Mrs. Martha Winfield, who was a resident and tenant of the basement flat, sought the landlord's consent to remove a substantial part of a load-bearing wall within the flat, which was about over 7 meters long. So it's a pretty substantial wall. The landlord was minded to grant consent, and there was lots of to and fro, but eventually it was all subject to securing adequate insurance, which she got. Dr. Duval, Julia Duval, was not happy. She was a tenant of two of the flats in the building. I'm not sure whether that's that 5-bedroom masonette that I mentioned, with the landlord's decision, and asked the landlord to secure an undertaking from Mrs. Winfield not to act in contravention of the clause 2.7 of the lease by cutting and maiming any of the load-bearing or structural walls. Dr. Duval confirmed, as required there in clause 319, she would pay the costs and provide security, and also indemnify the landlord if legal action became necessary. The landlord wasn't able to obtain or secure the undertaking from Mrs. Winfield, so Dr. Duval decided to issue a claim against the landlord. And she sought, amongst other things, a declaration that the landlord didn't possess the power to permit Mrs. Winfield to act in breach of that clause 2.7. Because by doing so, the landlord would be putting outside its power the ability to enforce the covenants in the lease. Here, the absolute covenant against alterations. When the matter was heard by the Court of Appeal, Lord Justice Levinson held that if the landlord were to grant the consent that Mrs. Winfield was seeking, it would be a breach of the absolute covenant, and the landlord would be breaching its absolute covenant with each of the tenants of the other flats who enjoyed that benefit of that clause. He said he thought it was implicit in the clause that it would be the case not only where at the date of any license the other tenant had already made the request and provided the necessary security, but also where an obligation under the clause remained contingent. So that was that. So the landlord decided to appeal, and the issue before the Supreme Court was quite simple. And if we can get the next slide up. Is a landlord of a block of flats entitled to grant a license to a tenant to carry out work to a flat which would be in breach of an absolute covenant in the lease of that flat, where the landlord has covenanted with the tenants of the other flats in the building to enforce the covenants in other leases if requested to do so? Dr. Duval, before the Supreme Court, had decided her view was that the Court of Appeal had arrived at the right decision. And her primary case, she had two bases of her case. Her primary case was that clause 319 did preclude the landlord from granting a license because it would amount to the breach of an absolute covenant. And her secondary case was it was implicit in each lease that the landlord will not be put out of its power to comply with the provisions of clause 319. To mention here, it's quite interesting because the judge, Lord Kitchen, who gave the leading judgment, referred to two cases heard back in the 1840s, which were all relating to cases relating contracts to marry and parties who breached those contracts. So it's interesting, we've got law from 175 years ago about marriages being used in property law. I've not seen that before. So the Supreme Court, the decision was they did find in her favour. They did accept that the first part of Clause 319, the landlord had made a promise with every residential tenant, and that each tenant knew that every other tenant would be bound by those similar covenants, and further that each lease would contain a covenant similar to that Clause 319. Also, that it was implicit in Dr. Duval's lease that there is a promise by the landlord not to put itself out of its power to enforce the covenant. So the Supreme Court therefore declared that the waiver by the landlord would amount to a breach of covenant, and the landlord's implied obligation not to denude itself of its enforcement powers. So the question of Dr. Duval's remedy was remitted back to the county court, but I expect that that won't happen. The county court will, the parties will probably, I expect, agree what to do going forward. So then what does that mean for us? It therefore will apply to leases which are in substantially the same form and where each tenant has the right to enforce a covenant against another tenant. So what will landlords have to do now? They will have to make sure that before considering granting any licenses or consents or waivers, whether the request, a tenant's request, is to alter a flat would be in breach of an absolute covenant. There are equivalent covenants, and the landlord is obliged to enforce those covenants. Now, the decision does not mean that tenants can't carry out routine improvements and alterations, which would normally fall within a qualified covenant. That was clause 2.6, which I mentioned. This is provided that if the clause or the works do not mean that they're going to involve any substantial alteration of to the structure, or waste or spawn, all those old-fashioned words which we have seen. Obviously, it's difficult because flat leases are in place for many decades, hundreds of years, you know, even in cases 999 years. So therefore, tenants will at some time will require a landlord's license of some sort to carry out works to their flat. They can't be held in aspects. So, you know, electrics will have to be updated, walls cut, and pipes inserted, and new plumbing, those sorts of things. So really, tenants do have a mutual interest to ensure that their flats are well maintained and repaired. So, but it is absolutely clear that the decision is, I'm sorry, I say absolute, it's an absolute covenant. If they go beyond routine alterations, then a landlord can't grant consent. If it does so, then other tenants could be claim the land was in breach of covenant and take action. There's a debate whether landlords could grant consent to a tenant if it could obtain unanimous agreement with the other tenants. Yeah, that's possible, but unlikely. In a large central London block of flats or in any other city, are you going to get unanimous agreement to one tenant carrying out alterations? So if you've got 100 flats and only one tenant does not agree to the alterations, then you're stymied. Now, one thing, probably only in a set of flats in prime central London and any other city centres where it's of quite high value, landlords do sometimes require substantial premiums to release or dilute an absolute covenant to permit works of the type proposed by Mrs. Winfield. Now, one possible solution that can be around this to allow a landlord to get that premium is provided that in the lease there's no prohibition, or there is the right for a landlord to develop. It could enter into an agreement with its tenant to carry out the works itself, and that, of course, the wall, like in Mrs. Winfield's case, is the landlord's wall, it's not the tenant's wall. Remove that wall and then grant a lease that space. Now, obviously, it's quite complicated, there's some complicated drafting, but the tenant itself could do the works as the landlord's agent. But obviously, as I say, there would have to be well-drafted documents, appropriate indemnities and securities, just to ensure that the landlord is protected. But obviously, only worthwhile if it's likely you're going to get a substantial premium. For instance, where you're going to knock two flats together, some lateral or conversion, or to extend possibly. So also, one of the other things which again there's a lot of debate about is, does it impact on other potential uses? And yes, it does. Not in this case, but in some cases you'll see the covenant, an absolute covenant not to alter the layout of a flat. So if somebody wants to move a kitchen or a bathroom, and that is moved to a place which is above somebody else's living accommodation, their bedroom or their lounge, they won't be very happy. So you have to be careful there. If a lease prohibits the laying of wooden floors and they're required to be close carpeted, again, that could have an impact. And landlords technically, although it's happened in hundreds, thousands of flats across the country, people prefer wooden floors rather than carpets. That's in itself a breach. Keeping pets, allowing tenants to sublet, all those decisions would be unlawful for a landlord to do. So although the decision relates to leases in blocks of flats, there may be rare instances where it does impact on commercial leases. And I know this is just on residential at the moment. But for instance, if there's a residential building which contains retail on the ground floor, flats in the upper parts, there may be some restrictions in those leases. So they would have to be carefully looked at. Now, one of the other things which again is a great deal of debate about is about whether tenants can take action. As I mentioned earlier, landlords have very often tried to obtain premiums from their tenants to release or to dilute absolute covenants and charge substantial premiums. So in those cases, it might well be the tenants in other blocks, if they find out about that, they could say, well, you landlord, you're in breach. Can I have some of that money, please? A landlord shouldn't be entitled to benefit from its own breach. It may cause problems of granting deeds, variations or surrenders, and various other things. Now, agreed tenants, technically, in this case, like Mrs. DeVal, wouldn't normally have a right of action against their co-tenant. But there is a case back from 1995, Hemingway and Dunraven, which dealt with a subletting, a breach of a lease in a subletting. And the landlord in that case granted an injunction requiring the subtenant to surrender its sublease to the tenant. And the tenant the subtenant was fixed with notice of the covenant and therefore was treated as a restrictive covenant. So I think that it's likely that that type of reasoning could also be applied in this case. As Chris mentioned in his talk, injunctions are pretty difficult to obtain sometimes, and or specific performance, and usually it's a very simple test that it's got to be just and convenient, damages aren't an adequate remedy, and the circumstances make it equitable to grant the order. So you can see in a case where somebody's moved their kitchen to a spot above somebody's bedroom, that it might be right in those circumstances to grant an injunction or an order for specific performance that the property be returned to its previous layout. So will the decision open any floodgates? I don't think so, but obviously there's limitation issues and possible defences that can be brought, and whether land tenants will want to bring actions against their landlords when they know they've got to give undertakings as to costs, and the landlord's going to bring the case and they're not going to have any control. It's only going to be really cases like this where it's of high value. So I don't think we'll see a huge amount of cases, but I think the moral or the point to take from this case is, before, if you're acting for residential landlords, or even if you're acting for a client who's a tenant, that before you seek license, you know the risks that you're taking if you seek landlord license to move or to do these types of works, which could be a breach of an absolute covenant. So that was a quick run through. I know probably gone beyond how long we've expected. So thank you. As Richard said, if you have any questions, happy to take them later. But otherwise, thank you all for listening, and stay safe and keep well. Back to you, Richard.
Thanks, Costa. Thanks, Chris. Yes, quite commonly for a bunch of lawyers, we've slightly overrun, but quite uncommonly, we're not charging. So lucky you. Thank you very much for listening today, and I hope you found all the talks enjoyable, or at the very least informative. As I said, if you could use the Q&A, if you have got any questions you'd like to pose to the panel, we will be collating them together and putting them on our coronavirus hub on the Mills Reeve website, together with the updates on timescales that Chris mentioned as well about the landlord and tenant remedies and the winding up. In particular as well, if you want to put in the Q&A tool any particular topics of interest to you that you might want to hear a future webinar about, that'd be most appreciated too. But again, that's all for us for today. Thank you very much for listening. Thanks to the panel, and have a good evening.
Thank you. Take care, everyone. Bye.